Actually, have Mr. Alejandro Mason, public too. Ashley,
Yes.
I have
Susie.
Mr. Alejandro Mason.
Alejandro who?
Mason.
That's
Mason,
public. Yeah, that's public.
Alejandro is my neighbor.
Okay.
Okay.
Hi, Mr. Alejandro. Can you hear me?
Hey, how are you?
Perfect. Thank you. Ashley, I have Miss Marian Janet.
You have who, I'm sorry? Oh, okay,
She's a
yes, she's
board
a
member.
board member. Yes, Miriam, she's a board member, so.
Hi, Miss Janet. Can you hear me?
Yes, I can.
Perfect. Welcome. Ashley, I have Mr. Carlos Reyes.
That's someone from the public.
That's one of my neighbors as well.
Perfect. Thank you. Hello, I have someone with a phone number ending in 6989.
Yes,
Who's this?
yes. Al Leoncio.
Oh, Leoncio, how are you?
Okay.
Okay, so you have a different connection. Okay, don't worry, I got you. There we go. Perfect. Hello, I have someone with ID, Dan. Not so sure what's the actual name.
That is JC Fernandez, board member.
Yes, he's a board member,
Oh, perfect.
so that needs to be
Hey,
changed.
that's my daughter's dance computer.
There we go.
My apologies.
That's fine.
Pero me veo yo aquí.
Miss Annabelle, can you hear me?
Yes, I can hear you.
Okay, perfect. Are you here for, I'm sorry, public comments or
I'm a neighbor.
your neighbor? Okay, perfect. Thank you. Lorenzo, have Miss Jocelyn Hernandez?
Member of the public.
Okay. Mr. Hernandez, can you hear me? Ms. Jocelyn Hernandez, can you hear me?
What's going on with Susanna?
Ms. Jocelyn Hernandez, can you hear me?
Yes.
Perfect, thank you. Welcome. Ashley,
Yes.
I have Ms. Lucia Brink and Ms. Valentina Piraulo.
Yes,
Members of the
I
public?
think she
Yes,
is
yeah.
with the school safety considerations.
Okay.
Hey, Herman, Susanna's
Yes,
telling
sir.
me that she's waiting to be let in.
I
No?
don't see her. I have like 3 people. Let me see if one of those is her. Usually I see
Check.
her ID.
Check to see if she's under a different
I just
name.
saw her.
Oh,
No,
you
she
got
just
her?
joined. I just saw her. She just joined.
How you doing? Luis Diaz is trying to get in. It's probably under La Gloria. Thank you.
Hi, Susie. Can you?
Hi, Mr. Julia. Hi, Mr.
Hi, Susan. Herman, with Fred Sandra, he's a member of the board, and I think it's noted as a public.
Okay. Give me a second. Let me check it.
Herman, the same thing with
Yes, sir.
Ms. Matos.
Ms. Matos, yeah, she just rejoined, so let me check it.
Oh, look how many people. Hi, Maurice. Hi.
Hi, Susana.
Hi. Hi, Mr. Fernandez. Hi, Mr. Senra.
Hi there.
Hello,
Susie,
Susanna.
Where? Oh, hey, Miss Janice. Hi, Miss Matos.
How are you?
Oh, wait, I'm not sure.
I have Susie, Mr. I. Diaz or L. Diaz from the day schools.
That's a member of the public.
Probably
Yeah,
somebody,
that's a member of
somebody
the
that's coming
public.
with the school project, the school safety.
No, Luis Diaz is my neighbor. My back door
Oh,
neighbor.
perfect.
Sorry.
I got it.
Hey, yes, I'm here. Sorry, I was on another meeting.
Maurice Acosta.
That's a member of the public.
Hermano, you good?
Yeah, a little bit complicated, but yeah,
All right.
I think nobody else has joined.
Right. What, Mr. Julia? Chair Julia?
Yeah.
With your permission, may I lay down some ground rules?
Yes, please proceed.
Thank you. Before we proceed, I would suggest that we do the following, Herman, is that anyone from the public, you go ahead and you turn off the video. So that way we're not distracted and it's just the board for the moment.
Okay.
Okay. For all those here tonight, before we get started, just so you all understand what's going on here, the first matter that we're going to be treating tonight or handling, if the board so chooses, this is just a suggestion, would be the quasi-judicial matter. That would be the easiest so that we can swear the folks that are going to be providing the testimony, then move from that to those that are going to be providing, those members from the public that want to be providing public comments, and then go ahead to the deliberation and move that. We have members here that are going to be presenting on one of the items that's an ordinance that's going to be before you. So that I would ask that we proceed as a second item. I mean, that's how it flows in the agenda, but I'm just letting you know why there's so many people and folks on this tonight. So we've got some folks that are going to be providing testimony on the quasi-judicial matter, and we've got other folks that are going to be providing feedback on the ordinance that's going to be for your consideration. So once we move in, I'll go ahead and I'll read the quasi-judicial public hearing notices, and then we'll move right into there. And I ask you all for your patience. This is something that not a lot of cities in Miami-Dade County are doing because it can be cumbersome, and because as far as dealing with a quasi-judicial matter, it is a matter of great importance. You are all wearing the hat of a judge today in listening to this variance request. And so I will guide you to the best of my ability, and so will Chair Julia, who has an appreciation for such matters as a fellow attorney and a member of that has done a lot of these land use type items. Okay? And so with that, Mr. Chair, you have quorum.
Okay, at this time, I'd like to call our planning and zoning meeting to order. First item on the agenda is actually the Pledge of Allegiance. So at this moment, I'd like to begin by the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic
For which it stands.
one nation, under God, indivisible, with liberty and justice for all. The next item is the approval of the minutes of our last and first Zoom planning and zoning meeting of April 7th of last month. So if there's a motion to approve the minutes.
No, después de ahí para acá, no se va. Después de ahí para acá.
I'll do a motion to approve the minutes.
Okay,
And I'll-
motion, I need a second.
I'll second it.
Okay, we have a motion that's been seconded. At this time, all those members in favor say aye.
Aye.
Any opposed would say no. Hearing no one opposed, the item is approved. So we've approved the minutes for our last meeting. At this time, now the next item would be the quasi-judicial public hearing, which we will be conducting via this meeting, the Zoom meeting. So again, this is definitely a new for all of us. So I'll hand it over to our very capable attorney to help us guide us through the rules of how it's allowed for the public to still participate. The idea is we still want the public participation as much as we can.
I apologize. If I may, Chairman Julia,
are we still kind of abiding by the let's hold back, just raise the hand until called upon, since I know there's a lot of participants here today?
Yes.
Might be
yes.
better than just us unmuting ourselves and interjecting.
Yes, we're doing the raising of the hand.
Okay, thank you.
With the permission of the chair, I'm going to read now the notices that I need to read, and this one's a little bit lengthier than usual. Then I will give you kind of a breakdown on how we're going to proceed again. And I just want to make sure that this runs as smoothly as possible so that all the conversation, everything is captured, and we don't interrupt each other. And as board member Yanis just mentioned, it's important that we don't. Please be advised that given the novel COVID-19 virus, Miami Lakes Town Hall is closed for the public, and public meetings will be taken via Zoom virtually. However, the Town Hall Council chambers downstairs are open for all those who wish to testify as part of the hearing, but do not have the ability to remotely participate in the hearing via video conference. Please be advised that the following items on the board agenda are quasi-judicial nature. An opportunity for persons to speak on each item will be made available after the applicant, who will go first, and then the staff, who will go second, have made their presentations on each item. All the testimony, including public testimony and evidence, will be made under oath or affirmation. Additionally, each person who gives testimony may be subject to cross-examination. If you do not wish to be either cross-examined or sworn, your testimony will be given its due weight. The general public will not be permitted to cross-examine witnesses, but the public may request the board to ask questions of staff or witnesses on their behalf. Persons representing an organization must present evidence of their authority to speak for the organization. For all quasi-judicial hearings, a list of proposed exhibits and a copy of the proposed exhibits shall be provided to the town clerk 5 days prior to the hearing in a format that is easily viewable on Zoom platform. All exhibits shall be clearly labeled so as to allow for efficient retrieval and display on Zoom platform. In other words, if you haven't presented the evidence yet or filed the evidence, we cannot present it tonight at the hearing. It needed to be presented 5 days prior. A list of all individuals who will be called as witnesses during the hearings shall be provided to the town clerk also 5 days prior to the hearing. At the beginning of the hearing, the town clerk shall call each witness by name one by one in order to swear each person in. Any witness who wishes to testify during the hearing and is not included in the previously provided witness list shall be sworn in after all the witnesses are sworn in and prior to the beginning of the hearing. All witnesses providing testimony must appear by video conference. A computer with Zoom capabilities, again, is being made available to the public downstairs in council chambers, where the deputy town clerk is at this moment. The town clerk or a court reporter shall administer the oath of any individual who's appearing by this video conference to establish the identity of the witness on the record, as well as the witness consent for the hearing to be recorded. In addition, comments to be considered during the hearing may be provided prior to the beginning of the meeting by providing e-comments by email or pre-recorded comments. The chair will allow for public comments using Zoom after the parties have concluded the presentation of their cases and before a vote is taken. In addition, the chair will request that the clerk read any comments or emails sent about the matter that is not subject to the hearing on the record. However, those comments standing alone are not sworn and do not qualify as competent substantial evidence on which this quasi-judicial board may rely, except they can be considered if they support the sworn testimony that is considered competent substantial evidence. The chair may exercise their authority to limit the length of time provided to an individual for public comment, and in addition, the chair may preserve the quorum and order. A phone number and email address have been provided for individuals who may have questions on how to access the meeting and participate. A town employee is present during this meeting and is in council chambers at this moment. That is where the deputy town clerk is at this time to assist the public with providing their testimony. In accordance with ADA, Americans with Disability Act of 1990, persons needing special accommodations should call town hall, and that was provided also as well. At this time, also know that this meeting is being recorded and is being live streamed. Mr. Chair, what I would suggest is after I read the variance, if you so choose, that you allow the deputy town clerk to go ahead and read the comments into the record. Actually, I take that back. Since the comments are part of public comments, this should be placed at the very end of the hearing, prior to your deliberation. What I would suggest is that as soon as I read this, the deputy town clerk swear in the applicant and the town planner who will be making their presentations. To the applicant, Mr. Cure, could you allow the video for applicant Lisbeth Cano?
Okay, give me a second.
Thank you. Mr. and Mrs. Cano, what I would suggest is, I know you have several folks here tonight that are providing testimony on your behalf. Can you identify who those folks are at this time?
Yes. Ricardo,
Okay.
Carlos,
Wait, let's go one by one. Ricardo, can you take the video off Ricardo? Herman?
Okay, give me a second.
The video.
Okay.
Okay, who's the next person? And
Carlos R.
give me 1 second. Ms. Clerk, can you write these folks' name in? Because you're going to be swearing them in one by one. After
Okay,
you swear
so-
in the applicant and Ms. Alonso, what I'd ask is that you swear each of these individuals one by one.
Okay.
So the first is Ricardo, the next one you named is,
Carlos Reyes,
okay, Carlos Reyes.
And Ricardo, what is your last name?
Flores, Flores.
Okay. Thank you.
You're welcome.
Herman, did you get Carlos Reyes?
Yes,
Yes.
it's there.
Okay. Who is your next,
Jorge Miro,
Jorge Miro?
Okay.
Okay.
Okay. Anyone else, Mr. Cano? Can't hear you.
We can't hear you.
Luis Diaz,
Luis Diaz. Okay.
I see.
and Alejandro Mason.
Alejandro Mason.
Give me a second. Let me rename Mr. Luis. Alejandro
Alejandro Mason.
Mason
Herman.
Nice.
and Anabel Miro.
Okay. Annabelle?
And you said Luis Diaz?
Yes.
We need to see their faces, though. Yeah.
Luis Diaz. Okay. There we go.
Yeah, Lewis is there.
And Annabelle?
Anabel Miro.
Right.
Okay, perfect.
Yeah, you're there.
And then I have Raul.
Raul?
What is Raul's last name?
Yeah, what is Raul's last name?
Can't remember.
Okay.
Pinheiro.
Excuse me?
Raul,
Pinheiro.
what is your last name? Oh, he's on mute.
Hold on.
What is your last name?
Pinheiro.
Miro?
Pinheiro.
Pinheiro.
Oh, Pinheiro.
Pineyro.
Okay. And Annabelle, what is your last name?
Miro.
Okay. Thank you.
Okay. So, Ms. Clerk, can you first swear in, and we're gonna have to do it one by one to preserve the record. If you can start by Ms. Alonso, then go on to the applicant, and then each of these individuals, one by
Okay.
one.
Okay. All right, Ms. Alonso, can you raise your right hand? Do you swear to tell the truth and nothing but the truth, so help me God?
I do.
Okay. Now the applicant. Randy, can you raise your right hand? Do you swear to tell the truth and nothing but the truth, so help me God?
Yes, I do.
Okay. Okay, Ricardo, raise your right hand. Do you
I'm sorry,
Lisbeth,
is Lisbeth going to be providing testimony as well? She's part of the she's one of the applicants, so.
Oh, okay. So, okay. Lizbeth, can you raise your right hand? Do you swear to tell the truth and nothing but the truth, so help me God?
I do.
Okay.
Now, Ms. Sheppel, with every other person, I would ask them to not only give you their name, but also provide their address for the record.
Okay.
We know what Ms. Alonso is and the applicant, but for all the other folks.
Okay. Ricardo, Floor?
Yes.
Okay, raise your right hand.
Okay.
Do you swear to tell the truth and nothing but the truth, so help me God?
I do.
And what is your address?
14450 Tababuya Lane, Miami Lakes 33014.
All right, thank you.
You're welcome.
Carlos Reyes, raise your right hand. Do you swear to tell the truth and nothing but the truth, so help me God? Carlos?
Yes, I do.
You do? Okay. And what is your address?
14425 Tabebuya Lane, Miami Lakes, Florida 33014.
Okay, thank you. Okay, Jorge?
Yes.
Okay, raise your right hand. Do you swear to tell the truth and nothing but the truth, so help me God?
I do.
And please state your address.
14405 Tababuya Lane,
Thank you.
Miami Lakes 33014.
Okay. Luis Diaz,
I'm here.
please raise your right hand. Do you swear to tell the truth and nothing but the truth, so help me God?
Yes, I do.
Thank you. Please state your address.
6801 Miami Lakeway South.
Okay, thank you. Alejandro? Alejandro, okay. Can you please raise your right hand? Do you swear to tell the truth and nothing but the truth, so help me God?
Yes.
Can you please state your address?
6821 Miami Lakeway South.
Thank you. Annabelle? Can you please raise your right hand? Do you swear to tell the truth and nothing but the truth, so help me God?
I do.
Thank you. And can you please state your address?
14405 Tababuya Lane.
Thank you. Raul?
Raul Pinheiro, 14410 Cedar Court.
All right, and do you swear to tell the truth and nothing but the truth, so help me God?
I do.
All right, thank you.
Okay. Since, Mr. Chair, since everybody has been sworn in, the next step I would, before I read this variance in and we be open public hearings, is for anyone that is a board member that either has to release ex parte communications that they may have had, or B, that they wish to recuse themselves, they should do so at this time.
okay, so, at Leoncio, we have to unmute Leoncio.
Yes.
I believe that Board Member Leoncio wants to recuse himself of this item.
Yes, I do.
Okay. Is there any other board member that would like to recuse themselves of this item or has had other communication that they would at this point like to bring to our attention?
Good evening. I spoke to the property owner just very briefly a number of months ago when I was showing the property across the street, just commenting on their project. That was my only contact.
Okay. Okay, so
Mr. Leoncio, if you could please, just for the record, you don't have to go into too much description. I know that you've filed your petition for recusal with the clerk, but if you can just state the nature of your, the reason why you're recusing yourself.
The reason why I'm recusing myself is I'm the architect on the project.
Okay. So what I would ask you at this time, Mr. Leoncio, is go ahead and log off completely off the meeting. That would be what you would actually do. You would leave the room. So in this case, you'll log off, and then what we'll do is Ms. Sheppel or myself will let you know once the hearing is over, so that you can re-log on, and Mr. Cure can let you back in. Is that okay, Mr. Cure? Herman? Thank you, Mr. Leoncio. Just wait for him to.
Okay.
And
So,
Mr. Chair, the variance, I will read now into the record. It's or if you want to read into the record, however you like.
I'll go ahead and, so it's item A, it's the variance 2020-0102 by applicant Randy Cano. This is an order of the Planning and Zoning Board of the Town of Miami Lakes, Florida, pursuant to section 13-305F1 of the Town of Miami Lakes Land Development Code, denying a variance request from section 13-1509B to permit a fence to encroach 15 feet into the minimum required 15-foot street side yard setback for the property located, this has to be wrong, at 7201 Miami Lakeway South. Miami Lakes, Florida, in the RU1 zoning district, providing findings, providing for denying the request, providing for appeal, and providing for an effective date. I can't. We need to unmute on this.
The correct address is 14410 Tabebuya Lane. That is a
Okay, so for the record, for the property located at 14410
Tabebuya Lane.
Tabebuya Lane.
Yeah.
Okay, at this time, if the town planner would present the staff's recommendation.
We should have the applicant go first.
Oh, okay.
And then the town.
We need to unmute the applicant, Randy or Lisbeth, if either one of you, whoever wants to proceed with your application.
Yes. Well, first and foremost, I want to thank everybody on the call. I got 9 neighbors on the call with me. I just wanted to thank everybody. Hope you guys are being safe with COVID-19. And I want to mention as well, we've been at this for about 5 months. I started doing this in December 21st. And it all started with me trying to replace my fence that was damaged by the hurricane. I had no idea I had to get a permit to replace my existing fence. And I got a notice that we had to get a violation for the fence not being done with a permit. We submitted plans to get the fence done. And we got refused because of the 15-foot setback. I bought the house like that. I bought the house in 2009, and it's been there. It's my property. It's not only 15 feet that you're taking from the setback, it's the whole property side. It's about 75 feet is what we're taking from me. My daughter rides bike there, and we have family outings. As Len mentioned, she did see me out there. I think I was doing a barbecue at that time. And so I do use the yard, and it's sad that we have to go through all this. I get the code, I get, the whole law, but I had it. It's nothing that we're doing wrong. All my neighbors are up for it. They're not giving me any setback. And Luis Diaz is my direct neighbor behind me. He has no objections for this happening. I've talked to them various times. Just pleading for mercy and for my own stuff back is really what I'm looking for.
Thank you. You want to say anything else, Lisbeth, or?
No, same. You know, when we saw this house, we fell in love with it because of that backyard. We pictured our future kids running around. Coincidentally, all of the birthdays are celebrated there in that area. That's where you put our table. That's where we sing happy birthdays. That's where 7 years of her life, our daughter, pictures are right there in that spot. And, you know, she's hurting too. She's like, Mommy, you know, but why are we going to lose this space that I jump into the pool, that I ride my bike around? So it's very personal and emotional.
Thank you. At this time, would then the town would be the appropriate next, or we should entertain all the different neighbors?
I think at this time you should, since part of their presentation and they've indicated are their neighbors, I think they should conclude their presentation, have their neighbors give their testimony, and Mr. Cano and Ms. Cano, you guys can ask them one by one to give their testimony. As the board, you guys can go ahead and cross-examine. You can ask them any questions if you'd like, Mr. Julia or anybody else here. And then let Susanna present the town's case.
Okay. So if it's okay with Randy and Lisbeth, if you want to, I mean, we could just go down the list of Ricardo and each one. Is that okay?
Yeah. Yes.
Okay. Ricardo, I saw that you're unmuted, so if you would like to state your comments for the record.
Well, what I'd like to say is that the only thing that this couple has done since they bought their house is upgraded their house. They invest a lot of money in their home. The neighborhood is good for it. But what I can't understand is the unfairness of this town treating this gentleman and his wife the way you do when you have a house across the street on the corner that's either a crack house and it's being run down, and I don't see anything being done. That's all I have to say. Thank you.
Thank you. Carlos Reyes, can we unmute him or go ahead, Carlos?
Yes. Okay. First of all, I have to say they're both great neighbors for our little community. Like the person before me said, the only thing they've done is improve the property and the beautification of it. I understand that goals are very important and for the safety and the beauty of the community. But in this case, I don't see it as a safety issue. We're talking only about a few feet that don't hurt anybody. And I think they should be given the opportunity to keep it like that, since they bought the house like that 15 years, like 9 years ago. And basically, I don't see a safety issue with it. I don't see any, any way that it hurts anybody. So, in my opinion, it's something that we should let them keep, since they had it since before. And thank you.
All right. Thank you. Thank you for your comment. George Mito?
Yes.
Hi.
Hi. I'm the neighbor across the street from them. I purchased my home across the street from April 2002. That's 18 years ago. And I can testify that that fence has always been there to the sidewalk. I don't understand why they want to push it back 15 feet. I have no idea why this is happening to them, but I don't think it's fair. And that fence, it's always been there. I can testify that to the sidewalk.
Okay. Thank you. Luis Diaz?
No.
Oh, did you conclude, George? Luis?
Hey, good afternoon. Good evening, everybody. As Randy mentioned earlier, I am actually the neighbor on the backside. I am the one that shares the fence line with Randy and the family since the day they walked in. I've been in my home for the past 10 years. a very, very happy Miami Lakes resident. The fence existence that unfortunately got damaged from the last hurricane is the same fence line that he's requesting just to make better, to fix due to the last hurricane, not asking for anything more, just what was there prior. As mentioned prior, this family, all they have done is enhanced the neighborhood by adding value to the home, as well as value to a family that you would want to live in the city of Miami Lakes. So as someone that shares property with them, and I so much respect that they did it the right way, right? They did not know that the rule of the ordinance was so you had to get a permit in order to put a fence line up, an already existing fence line, just fixed. They went about it, they went to the city, they did the paperwork, they did everything properly, right? Not behind the back, they did it properly. And now, unfortunately, they're sitting in a scenario right now that for anybody that would see it from an outside view and not look into the ordinance part would question this, so as the neighbor that shares the fence line, as the neighbor that shares, basically the property back to back, there is no issue whatsoever for us on our side, my family to his family, of allowing him to have the same exact family experience that they currently have when they bought the house 9 years ago, to maintaining that experience today and tomorrow, and allow them to raise their young daughter the way that she should be raised when she walked into Miami Lakes, and added value to this great city that we want to continue to add value every day as we move forward. So I would really appreciate that the ordinance is taken into consideration. Sometimes there are specific scenarios, specific situations that allow you to look into a little bit deeper. And I would hope that this fair committee right here would take that into consideration, because everyone that lives around this neighbor cannot see any reason why shortening of his family lifestyle should be taking place because of an ordinance that, for our eyes, just really does not seem fair at this point in time. Thank you so much for the consideration.
Thank you for your input. Alejandro Mason.
Hello, everyone. It's kind of hard to go after that, after Lewis, but yeah, man. Like I said, Randy, I've known him for a long time. He's a very hard worker. The little time that he's home, I always see him in the backyard, and I feel it's very unfair to take that escape, from the day in and day out hustle bustle from him. I'm more concerned about the cars speeding down Miami Lakeway South than his fence. I see no problem with it. Randy has done nothing but, made that house, as beautiful as it is today. So, like everyone said already, it's unfair to have that taken away, for something that, there's not going to be anything there. So I hope you guys can consider that and be fair in this matter. Thank you.
Thank you for your input. We also had Annabelle Amiro.
I'm here.
Hi.
Yes, we moved in back in April 2002, and that fence has been always like that. Like my husband said, they move in and the fence was always there. They're always outside on weekends, the kids and the family, and I don't think it's fair for them, to remove that area when they've been always like that since day one, since they move in. And none of the neighbors, I agree with that, because, we don't have a problem with that. It's always going to be safe, and it's going to be clean, and there's going to be maintenance there, which I don't know who's going to do maintenance in that area if you remove that fence.
Okay. Thank you for your input. We had Raul Piñeiro as well. Raul, can you restart, because the first words we had no muted.
After everything that everyone said, I've known Randy for about, I'll say 4 to 5 years. I don't live in the exact same street. I live across on the other side of the street. However, his house is always well kept. He's upgraded his house, painted his house. So if it's something that basically he wanted to encroach or something that he wanted to do that wasn't there before, maybe it would be an issue. But something that is just there, he's just replacing because the hurricane went and damaged his fence. I mean, I don't see an issue, and it's not hurting anybody. It's not encroaching anybody's property. It's a sidewalk. You know, it's nothing that kind of encroaches a bigger property or anything like that. So I'm against from what the town is not letting them do.
Okay. Is there any other public comment? I don't want to, I want to make sure that everyone in the public, from the public side, has made their comment.
If I can just add, I spoke more on the emotional and personal aspect of maintaining that, for us in our home. But like our neighbors said, the cause of removing that fence was because we had neighbors knocking on our door saying, we're walking by and the fence, the chain link fence, was dangerous for, people walking by. And so our only thought was, and we had like 20-foot palms, established already for years and years, that we had to cut down to replace that fence. And he was going to do it himself on a Sunday that he was off from work. He was called in to go and wasn't able to replace it. But all that was going to happen was we were going to replace that fence for our neighbors, for people who walk by. It was in no way in our benefit. So I just wanted to mention that, the reasoning behind actually removing that fence.
Okay. At this time, then, we would ask the town planner to present basically what the position of the city at this point.
Good afternoon, Chairman and board members, and good afternoon to the public. Susan Alonso for the Planning Department. This item is a quasi-judicial item, as the applicant has already exposed. The applicant is proposing to build a 6-foot Dura fence along the side of the yard facing Tabebuya Lane. It's a single-family home that is set back from the street side at 13.82 feet. And at this point, the code does require a 15-foot setback for any fencing on a side facing a street. This ordinance was established in 2004 in the town of Miami Lakes. It replaces prior county code, which allowed these fences to be built at the property line. However, this particular property, there was no building permit that could be found to establish the legality of the fence at the time of building. There is a significant, there is aerial photography that shows that the fence has been there at least since 1999. So it is worth noting also that the neighbor behind the neighbor behind, which is compliant with the existing code which has their fence at 15 feet, has submitted a letter of support, and I think he's present and has also spoken in favor of the variance. Again, the only reason we're really here is because they did remove the fence. If they had not removed the fence and requested an existing non-conforming structure determination, they would have been able to replace their fence. But the trouble begins once you remove the fence, we have no recourse to establish an existing non-conforming structure status for the item that was allowed in a prior code. So unfortunately, this is where we find ourselves. And unfortunately, because they did not meet the criteria for hardship, for practical difficulty that the code establishes, staff has to recommend against the approval. And here is in front of you for a decision. And I'll take any questions if you have them.
Now, going back to procedural wise though, if they would have replaced, because I'm hearing it used to be a chain link fence, the design of the fence is also different. Would that have affected us in your determination?
If they had come in before removing the fence, we would have, it's a quick procedure. It's basically a fancy letter that establishes the structure as an existing non-conforming structure. And as such, it would be allowed to be repaired and or replaced with a similar or better structure, because you can repair it. And yes, it would have been allowed to be replaced with a Dura fence of the same height or less. So we would not be able to increase the level of nonconformity. We would not be able to make it higher or any closer to the sidewalk. but it would be allowed to be replaced because it was already not, correct? So, but first we would have had to establish the existing non-conforming structure. Does that make sense?
Yeah, I just want to
That's a step that was not taken at the time because he removed it, and then the fence was removed, and then they notified the city afterwards when it was already removed. And at that point, the existing non-conforming structure is no longer there.
Right, but I just wanted to make my understanding of it is that even the material that they're trying to now do the fence, I mean, basically we have the issue of if they would have gone, and we could always do what if we would have done this, that, and the other. I'm sure if they would have known that then they would have gone to the town before and then sought the replacement, I imagine. But who would have known that specifically? There's another question that I have. There is a gazebo or some structure that is not an issue at this point either from the town's perspective.
It is not of, and please applicant correct me if I'm wrong, it is not a gazebo that is attached to the ground. It's a movable structure.
Oh, okay.
It did not require a permit. So no, there was no permit required for that gazebo because it's not attached to the ground.
Okay. Do any of the members of the board have questions? Okay, board member Yanes.
Okay, I guess right now we're just asking Susanna. Susanna, is there any reason why we couldn't find the legality of this existing structure before? So, I mean, we know that it's been there, at least you say, since 1999, and now we have testimony in that regard. Is there any reason why we can't find it?
So this goes back to the county. The county is a lot, let's just say it, a lot less careful about permitting than we are. There was a lot of things that the county should have required permits for that for some reason they didn't realize that things were being built without permits, and I'm just obviously making it up as I go. I can tell you there was a lot of structures that were built prior to town incorporation that are now hard to find permits for. Sometimes the permit is wrapped in with another permit, like maybe they put in the pool and the fence came in with the pool, but for whatever reason, the drawings, because we did look at the permits for the pool, for whatever reason, the drawings for the fence didn't get putting together with the drawings for the pool. So there could be a million reasons that are, not something that, because they're not even the town's records, because they're county records, it's hard for us to even be able to tell the why and the why not. The permit is not found. There is, again, that's why we went back to the aerials and tried to see at least continued existence. And correct, yes, it was there until at least in 1999.
Okay, so when the code changed in 2004, if it was legal, assuming hypothetical that it was done legally back in 99, would it have been grandfathered in?
Correct. It would have been grandfathered, correct. And at that point it would be, and it was considered prior to the demolition of the structure would have been considered an existing non-conforming structure. Basically something that doesn't follow the code today, but it's their existing and is non-conforming, even if we cannot even establish a permit for it. Does that make sense?
Yes. If they would have come to you or the town before putting down the fence, would we even be here right now?
No, we would not.
It wouldn't be an issue.
They would have a fence already. This would have been
okay.
Until.
Okay, thank you.
Are there any other questions from board members?
Yes.
Board member Senra?
Yeah, I have a couple of things. So what we're talking here, Susanna, is mainly a technicality, right? Of the owners of the property not realizing what they were doing after the existing fence was damaged by the hurricane.
Correct.
That is correct.
In a way.
And by now, I think that we have established that if they would have known what the law was or what the new regulations were, and would have come to the town would have approved whatever to replace the replacement of the fence.
I would have issued an existing non-conforming structure
Non-conforming.
letter, and then they would have been able to replace their
Okay.
fence.
And as I read their petition, the new fence that they are proposing will be a tremendous improvement of what it was there before, right? Was there before it was a chain link fence?
Correct. Chain link and some bushes.
So now we're talking about a more modernized type of fence, better looking, an improvement on the property.
You can say that, yes, sir.
Okay, all right. That's all I have.
Thank you. Is there any other comments or questions from the board? Vice Chairman Matos?
Through the chair to Susanna, please.
Yes.
Susanna, from a safety perspective, what are the ramifications, if any? Is it conceivable that there might be a safety component built into the fence if that was a concern?
Well, the pool, every time you have a pool, you do have to have your rear yard completely contained so that people do not wander into the pool. And in that sense, yes, they do need to have a fence. As to the location of the fence is what we're here to discuss.
What I'm referring to is the proximity of the fence to the road and the sidewalk.
The location of the requirement for the 15 feet adjacent to the sidewalk is really not a safety concern. There's 15 fences on property lines adjacent to sidewalks are allowed elsewhere in the town. They're allowed west of the Palmetto Expressway. The only reason that they're not allowed east of the Palmetto Expressway is because at the time of the town incorporation, there were many deed restrictions in most of these single family homes that required these fences to be built at 15 feet from the property line. So this is a little bit of when the town incorporated, they decided to take in these deed restrictions and enforce them uniformly throughout the east side of the town. West of the Palmetto, there is no such requirement.
Right, so while it doesn't aesthetically conform, so visually, so it doesn't
Correct.
look good, it necessarily from that perspective, it's not a safety issue because it's closer to the road, it's closer to the sidewalk. That's not an element of concern in this hearing.
No, it is not.
Or in the variance. Thank you.
Are there any other board members with questions at this time? Okay. One final observation, this is just in general. Correct me if I'm wrong, Susanna, but the intent of probably why the code is the way it is, and that's the reason why, unfortunately, they have to go through all these processes because there's a code. And we're not the code enforcement board, we're the planning and zoning board. So what we're looking at is as the entire, how a change in a property may affect the neighbors more than anything else. And one of the reasons why perhaps this was done in this fashion is to allow more of the green area, just like we have certain code restrictions with respect to how far you could build onto a lake or a slope of the lake, and it's to maintain a greenery around the area, and it affects property like this one in particular. It affects it because it's the side street, and that was the original rationale, probably why these things were done in this fashion.
Correct, and that is why it was not possible for me to recommend in favor of this variance, because it does not comply with the feeling of the neighborhood. And that is one of the, that goes to two of the questions on the variance requirements, on the practical difficulty requirements. And those two conditions were very difficult to comply with when the entire neighborhood really follows this pattern of development quite closely. There is no properties, there's very few properties east of the Palmetto that have legal fences at the property line. Most of them do follow the required development pattern of leaving the fences up to the 15 feet, including the rear neighbor who is present in the room right now. The property right behind them has a fence at the 15-foot line, as do the rest of the neighbors. So this was really an oddball property that had a different configuration. Again, the legality of which, you know, but it was allowed to be because it was there prior to town incorporation.
Right, and that's the dilemma on our side, because
That's the dilemma we're in.
absent the technicality, they would have been able to do this. So
Yes.
Can I through the chair?
please.
So yeah, that's I think my dilemma as well, because I think that all the neighbors have already expressed in favor of it, and it's clear that I think the purpose of the code, the way it was established, was for aesthetically. I think it may be more pleasing to have that setback. I have to take all the neighbors and their testimony into account. But I'm trying to figure out how it's going to look with the rear neighbor having their fence within what is established as a code. So 15 feet inwards, and then their fence being closer to the sidewalk, right? That's the only thing that I'm kind of just trying to grapple in my head. I passed by the home and I didn't see the fence when it was there before. So I can't really, I'm trying to picture how it's going to look. But again, it's just something that I'm grappling with to figure out how it's going to look once it's completed.
Susanna, just, and I'm going off of memory, though I do believe that we have, in the past, have given a variance for side streets east of the Palmetto. Maybe not all of the 15 feet, but a little bit less or something like that.
There has been some where you have, and I was about to mention, the applicant is requesting 15 feet. It is your prerogative to grant him less than those 15 feet if you see it applicable. There have been some variances in the past that have been granted for 5 feet, 10 feet, and I think 7 feet, not many. These are very hard-fought variances, is what I was trying to explain to him. Usually they get denied, but there's been three of them that have been approved with none of them with the whole 15 feet, but there has been 5 and 10, and I think a 7 in the past 10 years. But obviously he's requesting the whole 15 feet, and I believe, and I think Mr. Koyaya can correct me if I'm wrong, you are able to propose less than the applicant is asking for if that's what you're inclined to do, correct?
That is correct.
Okay. No, I just want to bring all the different things to, before we close out the public in case there's any additional public comment or anything like that. And then as a board, obviously we will discuss the motion. If the applicants would like to say anything further at this time before we close the public hearing, just let me know.
Yeah.
If I may, through the chair, I actually, we can ask questions of them also, correct?
Correct.
Right.
I do have a question for the applicant, if I may, through the chair.
Yes.
Before we close it out, because I know then we go into our own discussion, so I'll reserve my comments for that, but I do want to get a question for them.
Go ahead, please, board member.
I can't see Mr. and Mrs. Cano.
Yes, hello.
All right, I can't see you at all, but that's fine. I just want clarity on a few things. So when you bought your home, the fence was exactly where you're trying to put this new fence, right?
Yes.
Okay. You're not building a new, I guess you're not trying to get more space. You're just trying to get the space that you have when you bought the house.
Yes.
Yes.
The same space that we had.
Okay. And I drove by your house, and from what I saw, because right now you have kind of, not a real fence, but kind of something that you could almost see completely through, you seem to have, you would have to break ground. If I saw correctly, you would actually have to cause damage to your home to get it back to code, right?
Yes, we have about 4 feet of just dirt. That's where we had our palms planted before, and then immediately after that we have that's it, our pool deck.
Right. That's what I saw and what I thought of, to have to kind of you would have to undergo that as well.
Yes.
The last thing is the fence. I kept hearing people say it was damaged in a hurricane. So it was damaged in a hurricane. Is that the reason you were trying to replace it?
Yes.
Yes,
okay.
We provided pictures showing after the hurricane, the chain link kind of, I don't know how to explain it, kind of lifted up, whereas I don't know what they're called, what goes into the ground was lifted up and could, hurt someone, it can scratch someone. We tried putting some chicken wire and the tie strap to try to, fix it, but we did continue to get a lot of complaints from the neighbors. And honestly, we did it completely for the community, for the neighbors, because like I said, from inside of our backyard, it was paradise. We just had beautiful palm trees. We couldn't even see the fence. It affected us in no way at all.
Okay. And there aren't letters of support attached. It's referenced. I know you have a lot of support here, obviously.
Yes, there is letters of support.
I don't see it in the packet.
They weren't included in your packet, Ms. Board Member Yanes. But understand a couple things. This is a quasi-judicial, so the testimony you're hearing is part of the applicant's presentation, and that's evidence that you can use.
No, absolutely.
That's
I
substantive
was just
competent
wondering.
evidence.
Yeah.
The actual letters, which will be provided once this public hearing is wrapped up, as part of public comments, you can hear it, you can use it to support the testimony that you've heard, but by themselves, they're not testimony.
Okay.
They're hearsay.
Right. I get that. Okay, that's all I wanted. The new fence that you're going to put in, it's the same height, same everything?
So I'm glad you're mentioning that. I'm sorry, honey. I was going to mention it as well. Like I said, we were going to put exactly the same chain link fence. We had no intention in changing it at all. Once all this kind of unfolded, my husband's been very diligent about following whatever he was told he had to do next. Part of that was getting plans made. And within that, we found out that we could not put a chain link fence anymore. So then we went ahead and requested a metal fence, aluminum fence. But again, if a chain link fence is what needs to go back so we can keep our lands, our property, our backyard, then that is absolutely fine with us.
Okay, I have no more question. I will, I guess, reserve my comments when we close public hearing. Thank you.
I have a question, Raul de la Sierra.
Yes, go ahead, Board Member de la Sierra.
How tall was the fence, the chain link fence that you originally had?
3 feet.
And how tall is the fence that you're proposing to put?
6 feet.
Okay, thank you.
So the chain link fence was 3 feet, but the palms were ginormous.
All right. Board Member Senra, did you want to say something, or?
Yes, I just wanted to ask, do we know of any neighbors? But I'm familiar with the area. My nephew happens to live just a couple blocks from there, so I've been by there many, many times. Any neighbors that have that are not in favor of this type of fence being installed that we know of?
The item has been advertised twice because this was slated to be heard in the March meeting, and it has been posted for 2 months. And I have received absolutely no commentary to the opposite. I have no objections to be spoken of.
Thank you.
Okay. Is there any other comment at this time before I close out the public hearing? And okay, so at this time, I'm going to close the public hearing. And now the board members, basically the way this works is that we entertain all the public commentary, and then now amongst us as a board member, obviously still public, so you hear everything that we're saying, we could discuss the item, and then I will call for a motion to either approve, not approve, approve with conditions, or something to that effect. That's just so that I could explain it to everybody that's listening to us and seeing us. So at this time, oh, go ahead.
Before you proceed, Chair, I think it would be proper for the clerk to read the public comments that we received by email.
Okay.
There is a letter of support from Miss La Gloria Diaz. She's a neighbor. There's another letter of support from Mr. and Mrs. Reyes, also a neighbor. There is a letter of support from Rick, no last name, also a neighbor. There's another letter of support from Alicia and Rob, also a neighbor. And there is another letter of support from Mr. and Mrs. Casanova, and they are also a neighbor. That's it.
Okay. So at this point, is there any other thing that we want to enter into the public record?
No.
No. Okay. So now the open to the public section would be closed at this time, and now it's for public for commentary amongst us as the board members. If there's commentary or if anyone wants to present a motion, I open it up to our board members.
To the chair.
Go ahead.
This is Press Sandra. I tell you what, I have always been one that has respected pretty much all the codes and try to deviate, very little from, from approving anything that goes against codes or what have you. But, based on what I have heard from the neighbors, based on what I heard from the claimants, Mr. and Mrs. Cano, knowing where the house is located, and it's not on the main thoroughfare. It's it's inward from Miami Lakeway south. I would like to make a motion to approve the variance, even though it's not following the the proper code, based on all the history that we have been told, that the fence was there, that the the same distance, there was damage. They didn't know what the right way of they had to apply for permits or whatever, based on what they knew, and they seem to be a pretty hardworking family, an honest family, and young family here in Miami Lakes. I'd like to make a motion to approve the variance, Mr. Chairman.
I'll second that.
Okay, so we have a motion that's been, as a motion to approve the variance requested by the applicant. It's had been seconded by board member Yanis. If we want to, like, we could open up still now for discussion amongst us before we take a vote.
I have a comment through.
Go ahead. Go ahead, board member Yanis.
So, and I know some of the concerns that were expressed. Truthfully, initially when I saw it the first time around, I just mentally viewed that how awkward it may look with you know, the one house being compliant and the other house not being compliant. So I understand that while we, you know, may want to help every single family that comes here, we also do have an obligation to follow the code, and there is this aesthetic component of the community and the greenery that we want to put forth. So I did initially struggle with this and how it may look. However, my fundamental problem with this is that it was already there. That is my fundamental problem with this. My fundamental problem is that if I almost see it as a technicality. If they would have taken the picture and given it to Susanna, we wouldn't even be here. So you have them pay this money, try to be compliant, try to make their house look better, and now we're going to enforce something that they didn't really need if they would have just taken a picture before they removed it. I really find that you know, to be unfair and not really the policy behind the issues that we should be here to resolve. You know, I find Mr. Mito's testimony really compelling. He says he's been there 18 years and it's been there 18 years. I find that to be convincing. You know, Mr. Diaz is the house immediately adjacent to him, and he says, I don't have a problem with it. If anybody's home, I think, may be impacted in terms of property value or whatnot, it's going to be his. If he goes to sell that house and someone's going to say, well, the house next to me, look, it's going to be on him, and he's here actually advocating on their behalf. I find Susanna's testimony also compelling, because when I asked if they would have done it, we would even be here, she said no. We wouldn't have even had to worry about it. The family was faced with a situation, in my opinion, so we go through the factors that Susanna had put forth. And one of the factors, you know, we say they're not compliant with essentially a circumstance that's beyond their control. You know, for lack of the exact magic words, I disagree. I think it's completely beyond their control. You know, they bought the house not knowing that there was an issue or zoning. No one is expected to be a code expert when they buy a property. You know, that house had that fence there. They would have never changed their fence, but for the fact that a hurricane came and messed it up, beyond their control. Then they tried to fix it. To their credit, they've actually put a lot of, and I pass by that all the time. I drop my kids off at school and I go right by Tabule, and I've gone there multiple times. And they've improved the home. And they're doing what we all hope most residents would do, which is improving it. And I know I tend to advocate sometimes for the petitioner. In this instance, I really was inclined to not do so, but I really think that everyone has a right to this, you know, notice and due process. And at the end of the day, they bought a property that, you know, they're not asking for 15 feet. They're asking for what they bought. They're not asking for anything more from us. I don't think it's fair to say, you know what, let's give them 7. You know what, let's give them 8. No, they bought the house at 15. They're putting the house in the exact same place the fence was before. I think make them whole and let them have what it is that they have. And unfortunately, if they would have taken the picture, we wouldn't even be here. But I think that goes more to the side of, you know, let's allow them to keep what they had, because I do think it was there since 1999. I do think they were legally grandfathered in. I do think that they didn't know this technicality to take the picture and get it. And I guess that's my biggest issue. If they bought the home compliant and we're trying to take 15 feet, I would tell you no. I would tell you no, you're kind of taking a little too much to me. But since you bought the home, and since Susanna said if you would have just taken the picture, you would have had it, you know, I would, I guess, urge my fellow board members to I guess, look at that one fact. And other than that, I'm yield back.
To the chair.
Board Member Fernandez?
Yeah, I'll be brief. I came here really, I think that Board Member Yanez said it well. I think that I came here with the intention of actually not approving this variance. But I do think that there's a lot to be said about them buying the home with the existing fence, and for us to take it away, to take that 75 feet or whatever it is, at 15 feet by however many feet it is in width or length, if you're looking at it from the side, I think it would be unfair. So I'm gonna approve it.
If I can.
Yes, Vice Chairman Matos.
It's a technicality in my mind. I went by late this afternoon to have another look because I wanted to see it again. The one thing I'm a little bit surprised about was that when they purchased the home, obviously there was a survey done, and I'm surprised it didn't come up. And maybe it did. Sometimes things are missed because if the fence was there, it would have, I think, been noted on the survey that it would have been in the setback. Nonetheless, I think that there's no intent here to do anything other than the very best thing that they're intending to do for their neighbors. They repeatedly said that this was a safety issue, being that the fence had been damaged in the storm. While they couldn't see it or hadn't been exposed to that or experienced that, clearly it had impacted their neighbors. By the same token, I don't think that I've ever seen a situation where so many neighbors have come out in support. I think that speaks volumes to us on the board. I'm sort of a stickler for details too, as far as the compliance goes. And when we had looked at this before and looking at it, I think that if enough due diligence has been done to ensure that that permit doesn't exist or there was no record of that, that's not their fault, nor is the fact that it might have been missed on a survey when they purchased that property. If it wasn't noted or an exception wasn't made. So I'm going to proceed ahead and vote in their favor as well. Thank you.
Board
like to
Member
say
Garcia?
something. Yeah, I concur with Ms. Yanes and Fernandez and Matos. I think that it would be egregious to have them rip their yard up now after everything's been there and they've been enjoying it that way. There is the buyer beware. When the people that know real estate know there's a buyer beware, that you need to do your due diligence. But I think it would be wrong to make them tear up their yard. I'm going to vote to allow them to go ahead with this fence also. Thank you.
Thank you. I think the other, I mean, I'm also very inclined at this point to vote. I think, like most members, initially our concern is the whole greenery of the area and in general, but in this particular instance, number one, the technicality part, which I also find, troubling, that we would have to make you come through this process to do that. So it's just, unfortunately, sometimes it's just part of the codes and part of the things that staff and no one can do anything about. I mean, it's what's written in stone, and we can't change the rules halfway. So luckily we have this platform for our residents, and you've done a great job in bringing your neighbors, which are the ones that at the end of the day, we have kind of a weird situation as the Planning and Zoning Board, because while we're looking out for your interests, we really are looking out for the town's interests, and we never try to hone in on whether we personally like someone or doesn't like someone, or like the plan or don't like the plan. It's really what the effect on the entire neighborhood. And again, you brought your neighborhood. Your street is very peculiar. It's a small street, and you have, I don't know, about half of your neighbors literally on the call. So that's great. And I think that speaks more than any personal decision or personal bias that I may have internally at the beginning looked at it. Additionally, when I look at it, I'm looking at your neighbor Diaz and your home. The way your home was built, it was literally built to, basically look toward us to go back and take away, the 15 feet and bring it 5 or 7 or 8. It's really messing up the way your entire yard is, which is different than your neighbor Diaz's house, the way that house is done. I don't see that it's going to be much of a problem. So I'm also going to be inclined to vote in your favor. So it looks good for you guys. So if there's any other additional comments, or I could call or the roll call vote. If the assistant city clerk can call the roll.
Yes. Okay, board member Yanis.
Yes.
Board member Fernandez.
Yes.
Board member Senra.
Yes.
Board member Raul de la Sera. De la Sera?
Yes, I'm voting yes.
Yes, okay. Vice Chairwoman Matos.
Yes.
Chairman Julia.
Yes.
Motion passes.
Congratulations. So this item has passed and the variance has been granted as requested by the applicant. The next item would be item B.
Really quickly, please contact me tomorrow morning so we can arrange what you need, right?
Thank you. Thank you to everyone. Thank you so much.
Thank you so much, guys.
Thank you.
Congratulations. Stay safe.
Thank
Enjoy
you.
it. Enjoy it.
So much.
Enjoy it.
More birthdays.
Happy Cinco de Mayo, right?
Enjoy it, disfruta.
Thank you so much. God bless you guys. Thank you.
Chair, I think
Board member Leoncio.
Yes,
gonna
I'm in the middle of contacting him.
All right. And you're more than welcome to stay looking at us live. So
We're gonna go run.
all right.
Bye.
Go play.
Thank you.
Go play. Go play.
That ran pretty smooth considering how many people.
I think so. Yeah.
We got him busy back there controlling the scene.
He's doing a great job. Awesome job.
Hey, Susanna, I have a question for you.
Yes, sir.
I heard one of the neighbors mentioning that why didn't we do something about the crack house that they have on a corner?
Oh, yeah.
Is that something that we should somebody should look into it?
I have not
Because
heard of any issue in any house in the neighborhood.
we don't need a crack house.
No.
Oh my God.
Probably a code. I know which house. It's probably a code enforcement issue, right?
Right.
Maybe code enforcement.
Yeah, they usually get taken care of through that process. They don't necessarily reach up to unless they.
Yeah.
That property's in foreclosure.
That will probably put me on YouTube. I found myself being on YouTube based on a comment that I made when we were talking about that halfway house that that was being ran here in the town, and I guess I was spoke very very harsh about it. So they put me on YouTube.
Oh,
Yeah.
Oh my goodness.
That's an honor.
Yeah. Well, for that is an honor. I consider it.
He's logging back in.
Yeah, I see.
I just admitted.
Okay, so we have board member Leoncio back. Is he back?
Yeah, he's here.
Okay. Okay, so the next item on the agenda was item B, the synthetic roofing in the townhouse districts. This is an ordinance of the Town of Miami Lakes, Florida, amending Chapter 13, Article 4, Division 3, RUTH Townhouse District, Section 13-444, Development Regulations, providing for severability, providing for inclusion in code, and providing for an effective date. Don't know if members of the public wanted to give an opinion regarding this item. Do we? No. So
I don't think we have anyone from the public.
I think
May I suggest, we have several members of the public. They can unmute themselves if they would like to speak. All of them have cameras and mics, so it's up to you. You want to?
They're here for
Yeah, I believe that
they're here for the next item.
Right. So our town planner, if she could guide us through this one.
Good evening again, board members and chairman. This item came to the town as a new business item for the town council on March 1st, on February 2020, on the February 18th, 2020. The town council would like to add as an allowable material synthetic roofing for townhomes. This type of material for roofing had been previously allowed for single family homes and for multifamily and commercial buildings in 2016. The townhomes, though, were left out of that variance of that ordinance back in 2016 for reasons that had to do with deed restrictions and concern about HOAs not allowing them. In the recent months, though, some HOAs have reached out with interest to allow their townhomes to utilize these new materials because they are becoming better looking and better and more resilient and more compliant with regulations. And we find that this is a good time to maybe allow them with the caveat that they have to look exactly like the materials that are being, that are existing in the rest of the time in the community in the development, so that they don't look different than what is already existing.
Okay. I just have one question. The definition of the administrative official, is that your title?
Correct. So that's a very good question. Thank you. Because we need to make sure that these roofing systems are similar in appearance to the existing roofing system. Usually we get a letter from HOA from what is called the official authorized body for each association. Trouble is that we do have some townhome communities that do not have HOAs and therefore have no official authorized body to give this release that they find this material is compliant with their design requirements. And for this purpose, we are changing a little bit the requirement that whenever there is no HOA, whenever there is no official authorized body, that an HOA of sorts composed of the administrative official, that would be whoever is in my position, the town planner, plus the building official, plus the town manager. So between the three of us, or the three people that are in those three positions, they can come to consensus as to whether the material complies with the aesthetic requirements, and this is only about aesthetics, with the aesthetic requirements of the particular development or the particular townhouse community.
No, I was just not sure if it was the administrative official, if that was your technical.
That would be my position, yes.
Right, okay. That's the way we refer to it in our code, I guess.
Correct.
Okay. I don't know if any of our board members have questions that they want to address to the town planning. Board member Senra?
No, I really don't have any comments. I think this looks to me like a no-brainer because we already approved this for the single-family homes. And so to me, it's the same thing for the townhomes, as long as they match the structure and of the other roof tiles. I don't see any problems in approving going with the town recommendation.
Thank you.
Mr. Senra, just to make a correction, this would actually allow, if the HOA is okay with it, for there to be differences between one townhome and another townhome in the materials and also the color variations, should the HOA board be okay with it. The other component there, it's in your memo, is that in a lot of these HOAs, there are deed restrictions that don't allow them to do this at all. That doesn't mean that us as a town we can't create an ordinance that allows it generally for HOAs to have, the ability to do this. So that's what the ordinance is doing. It's kind of putting it out there and leaving it into each of the HOA's hands, how they want to handle it.
Board Member Fernandez.
Yeah, so thank you for the clarification, our town attorney. So that's what I was wondering. So if we allow for it, I guess really our only job is to include it into our code and let the HOAs decide on whether or not they're going to allow it. Because I was thinking if as the homeowner needs to replace the roof, there's definitely going to be a variation, right? If they're not all going to do it at the same time, especially the fee simple, the lot and block townhomes. I mean, Villa Vizcaya are, even though they look like townhomes, they're actually, and my colleague Lynn Matos she can agree with me. They're actually they're undivided interests, which would make them legally condos. So that would be a little bit easier because I think they all pay into this pot where they're going to replace the roof all at once. But a fee simple townhouse, you may have one that replaces it, that chooses to replace it or needs to replace it today, and have the next door neighbor not replace it for years, right?
You make a very, very, very good point. And this is most likely why townhomes were left out of the 2016 ordinance, because there is two types of townhomes. One is where a single building that is interior subdivided in the interior, but the roof structure is one roof structure throughout. That kind of structure, obviously, even if only one townhome needs to repair their roof, you would not allow them to have any other different type of roofing that is not exactly the same as the rest of the townhomes in their row, because they would have to replace the entire roof at the same time or repair it little by little with identical materials. So if they have a tile, they would have to bring in the exact same type of roof tile that they already have, or the same exact concrete tile that they already have. There is other kinds of townhomes though that have separations that go all the way up to the roof, and sometimes all the way past the roof line, where the individual townhomes do have what is an individual roof to them, even if they are attached to the next door neighbor. In those cases, it is completely possible to just repair or replace only the roof that is on top of your particular unit. And in those cases is where this would be most useful. And then if obviously the only caveat is that it would have to match in color and in type, so that if you have S-shaped tiles in the rest of the building, then you would have to have S-shaped synthetic roof tile with the same coloring as the rest of the buildings in the place, so that they all look uniform.
If I can.
Yeah, Vice Chairman Matos, please.
To the chair, Susanna, other municipalities are allowing this different and alternative roof types for their multifamily structures. How are you seeing that?
Again, the trick, this is one of those that is being difficult, because the problematic situation with townhomes is whether or not they are one single roof or whether they're individual roofs. There is a lot of communities that are very strict about what kinds of roofing they allow at all, and a lot of communities do not, a lot of municipalities do not allow any synthetic roofing, do not allow any metal roofing, do not allow any shingles, do not allow asphalt shingles. We are, however, allowing all these other materials because they are coming along in type and quality, and because residents are choosing to use them for their roofings. Again, the complication with townhomes is it's hard to make one fast rule for all townhomes, and particularly because the types of townhomes that we have in Miami Lakes are both types. We do have the types of townhomes like Villa Vizcaya that have a single roof for several townhomes, sometimes 10 townhomes at once. And then we do have many townhome developments that are completely individual, that have a complete separation all the way past the roof line. So because we do have both types, it is unreasonable to sort of penalize the ones that could potentially utilize this roofing system one at a time for the ones that couldn't, because they just couldn't have any individual re-roofings, period.
And if I can, one more question. Do we have any input, or have we received any input from the HOAs as to their feeling about this? They're supporting?
This has come directly from one HOA, which would like to begin to have these roofs on the next round of replacement. So this is a community that has individual roofs, and there's at least one property owner that would like to put this, and is the HOA president, as a matter of fact, that would like to put this in his home. They have already gone through this particular association, and it has already been approved by the association as a material for their replacement. And obviously other property owners will probably start asking for this type of material in the future, should we approve it.
Are you at liberty to say which association it is?
I'm at liberty, but I forget.
Okay, that's okay. Just ask.
I try very hard not to do, because you can't make the rule just for them. So I'm trying.
That's what that was my point. And there's so many variants, so many varieties of roof configurations amongst the townhomes in Miami Lakes. As Board Member Fernandez indicated earlier, we've got a wide variety. So to penalize one where it could be utilized in another, obviously it's being governed by the association. And when there isn't one, certainly you and the remaining board members, if you will, are certainly qualified to make that decision. Okay, thank you.
Board member
question.
Yeah.
From Suzanne, this is not going to allow shingled roofs, is it?
No, sir. This is just it's called. We're trying to put in an ordinance that does not utilize a commercial trademarked product, so that they were using the synthetic roofing, and it's referring to the ones that are like a composite plastic material. It's a petroleum product that is made for roofing, but it's not shingles. No, sir.
Okay, because the shingles are horrific.
It's not for asphalt shingles. And the convenience of this synthetic material is that it's light enough that it could be an appropriate replacement for asphalt shingles, because it is very light. So in a way, we're kind of like giving a really good option for any asphalt shingles that we may have out there that need to be replaced in the near future.
But it would have the look of the barrel tile.
It would have the look of the barrel tile, but
Okay.
the weight and the attachment of an asphalt shingle. So no need to reinforce the roof, and no need to reinforce in order to be able to put in something heavier.
Okay, thank you.
Does this would also include the metal or no?
Potentially, yes. We have not added the metal at this point for the townhouses, for the same reason. We have not been requested by any one association to use metal in their, and that would require for everybody to change their roof to a standard metal seam. They can still use the metal roofs that look like barrel tile to match their existing, but the standing metal seam, which is what we just approved for other properties in the town, would require all of them to change their roof.
Okay, so by us, I mean, obviously this is going to be approved or not approved by the board, our board of, we don't have the authority to approve this or not. So we could just recommend in favor or not. If the board of commissioners here would approve this, it's not going to automatically allow for the metal roofs that we approved for the houses.
Not for the standard metal seam, because there's the requirement that it look like the existing material that is there right now. So yes, they could still, and they are already allowed to use the metal roofs that resemble barrel tile, but not the standing metal seam, because that would require all of them to change it at the same time, which is really unlikely.
I'd like to make a motion that we approve it according to the town's wishes.
Okay, there's a Sierra. Is there a second?
And I'll second that motion.
Okay, it's second by Board Member Senra. I don't know if there's commentary that somebody wants to mention something, or we go straight to vote. Seeing, I don't think anybody wants to comment any further, we can go ahead and call a roll.
All right, Board Member Senra,
Yes.
Board Member Leoncio,
Yes.
Board Member Yanes,
Yes.
Board Member De La Sera,
Yes.
Board Member Fernandez,
Yes.
Vice Chairwoman Matos,
Yes.
Chairman Julia.
Yes.
Motion passes.
Now, the next item on the agenda is the school safety considerations. A question to our attorney, is this public comment? Do we need to swear in?
No, you're not. Thank you, Mr. Chair. To answer your question, this is not a public hearing. This is your consideration of the ordinance. And so at this point, you don't need to swear them in. They're going to be providing these individuals who you're going to be hearing from are students from Miami Lakes Middle. A lot of this came from them. It was an idea that they crafted. They presented to Mayor Sid. Mayor Sid presented it as a new business item. And both Ms. Alonso and I have been working with them in crafting this ordinance. And I believe what they wanted to do this evening was present, this is part of their project that they have in their school. And had COVID-19 not plagued us, they would have been presenting this live. So if we could indulge them, it would be great to hear from them and see their presentation.
Perfect. Okay, so for the record, I'm going to read the ordinance title, and then we open it up to them. Is that the proper procedure?
I think so.
Okay, so this is item C, school safety consideration. This is an ordinance of the town of Miami Lakes, Florida, amending chapter 13, article 6, division 1, creating section 13-1617, school facilities safety considerations, providing for repeal of laws in conflict, providing for severability, providing for inclusion into the code, and providing for an effective date. So at this time, I'm turning it over to the drafters or the coordinators.
Good evening. I hope all of you are doing well. First, we want to thank you for this opportunity to allow us to speak today. We submitted a PowerPoint to the town manager or town clerk, I'm not sure.
So, Mr. Acosta, would you like me to start sharing my screen?
Yes.
Good. This moment, I'm going to put the rest of the participants in mute, and I'm going to have Mr. Acosta microphone on. So bear with me 1 second. And just a recommendation for everybody. When you see the presentation, you might have the video on your side, all the members. You have a couple of options. If you see on the top of the ribbon of videos, you have like 1 dash, 1 rectangle, 2 rectangles. If you click on the first one or the second one, the video will minimize, so you will see only the speaker. So that way you can see the whole presentation. So with that being said.
Thank you. First, this PowerPoint, I'm not the only one presenting. There's different people are going to be talking on different slides. So if there's a way we could unmute the rest of my classmates. Thank you.
I'm sorry, guys. We disconnect for a second, so I couldn't see you or hear you. Apologize for that. I'm gonna go back again to resume the presentation. Is that okay, Mr. Acosta?
Yes, that's fine.
Okay, sorry, I just had my phone disconnected. I don't know why, but give me a second. Okay. Okay.
Okay, thank you. So today we will be presenting an ordinance that deals with school safety and public commercial and residential buildings and how close their proximity is to schools. Could we please go on to the next slide?
This ordinance will establish that commercial and residential buildings will be a safe distance away from schools. And even though Miami Lakes hasn't had any incidents, this ordinance is here to prevent that any will happen in the future.
Thank you, Lucia. Could we please go on to the next slide? So we thought we would share with you our inspiration to this ordinance. So here you see a photo of what will become Lucida Apartments, constructed by Citrus Construction, located alongside Northwest 77th Court, next to Bob Graham Education Center and Courtyard by Marriott Miami Lakes. This picture was taken April 4th. The apartments will consist of 8 three-story buildings, a total of 108 units. The setback from the school property is about 5 feet. Since the setback is so low, this would allow future inhabitants to overlook the school dismissal and get extremely close to the students during this time. This led us to look into how buildings near schools, both commercial and residential, could pose a safety and security threat to schools. All of this research eventually led to the creation of the ordinance. Could we please move on to the next one? Thank you. So here we see a chart of school environmental safety incidents in Miami-Dade County. So as you can see, the numbers have been decreasing since 2006. This is because these are also incidents within the school. So drug use, alcohol use, but also exterior threats. So as you can see, although the numbers have been decreasing, they are still in the 3,000 and 4,000 range these last 3 to 4 years. And our hope is that this ordinance will not only increase safety from exterior threats, but also interior-wise regarding alcohol use, for example. Next slide, please. Ms. Crystal.
I'm sorry. The number of school shootings in the U.S. in 2017 was only 47% of the amount of school shootings that occurred in 2018. This number has stayed nearly the same in 2019. The average number of school shootings in these years were about 10 per month, and 2020 had been following this exact same rate before schools had closed due to the pandemic, meaning 2020 most likely would have had not the same, but if anything, more school shootings than in these past 2 years. Would you please move to the next slide? Thank you. Florida is the state with the 3rd most school shootings in the country and is ranked 2nd in states that have had the most fatalities with these shootings in the US. this establishes that Florida is already significantly more vulnerable to school shootings than the majority of the states in the U.S. Thank you. After presenting all of this information, we wanted to implement an ordinance in this town of Miami Lakes that would hopefully keep our schools safe. Next slide, please. In this ordinance, we wanted to implement any new construction within 25 feet of schools had to have at least an 8-foot fence of masonry along any property lines that is shared along school property or recreational recreational areas near schools. We also wanted to implement that any commercial or residential buildings had to be at least 25 feet away from the schools and any property lines from schools or recreational areas. Next slide, please. In regards to buildings that have already pre-existing buildings, we wanted to implement the fact that if a building was renovated more than 50%, we wanted it to meet certain requirements, such as no balconies or catwalks, terraces, or operable windows that face the school. And we wanted all roofs to be sloped.
I'm sorry, could we please go back to the previous slide?
This section of the ordinance mainly states that any alcoholic establishment needs to be within 250 feet of any school facility, and any alcoholic establishment within 1,000 feet have to have a conditional use in order to sell those alcoholic beverages. Next slide, please. This graph mainly shows that 76% of Florida counties have not put in place this specific regulation yet, but 24% have already put an alcoholic regulation distance from school in place already. Next, please. Statistics have proven that identity of any alcoholic advertisement or alcoholic establishment within 1,500 feet of school facilities have had very increased amount of underage drinking in those schools. Over the past years, it's been shown that about 4,300 underage youths have died of excessive drinking, and that is a cause of these alcoholic advertisements and establishments being so near to school facilities. Next slide, please.
Section E of the ordinance prohibits for there to be any firearm or weapon sale establishments or shooting ranges within 500 feet from any type of school property. Next slide, please. We've seen in the past how a gun store near a school in Michigan was robbed. This put all the kids in that school in danger. In addition, there have been several articles questioning the safety of having gun stores near schools and stating that it could not only lead to an increase in school incidents, but put kids in danger in general. Next slide, please.
This section of our ordinance will give a 500-foot setback from all chemical and gas facilities and schools. And next slide, please. Through our research, we have found incidents where terrible things have happened. For example, the West Texas chemical explosion killed 15 people, injured hundreds, destroyed 150 buildings, including 4 schools. And then there's Trail Ridge Middle School, where methane and benzene were leaking onto the school sites, and kids were even playing on the remains of Ryder Well. And these schools are not alone. In the US, 12,000 schools are near facilities like these. Also, a study by the University of Colorado found that the chemicals emitted by such facilities could increase the probability of cancer. Next slide, please.
We thank you for your time and for listening to our presentation. I'm not sure how the procedure works, but if questions are allowed to be asked, we would be taking any at this time. Thank you.
Okay. Thank you for that presentation. It was great.
Great job.
Basically, the way it works is, yeah, the board members could, if any of the board members have any direct questions, we can ask of any of the of the participants. I don't know if any of our board members have any questions. Board member Yanis?
I just have a comment. I think you guys did a great job. It takes a lot of guts to do what you did and to do better and to, think about how you can help the community. And, at your age, I don't think I was doing anything near that. So to look around and gain inspiration and think about how you, can protect your fellow man, not in one way, but in multiple ways. You should all be very proud of yourselves because what you did here today is really, really commendable. And I know everyone echoes that. So great job, you guys, for putting together a wonderful presentation. I only wish I could have seen it in person, but great job, really.
Thank you.
If I can, Chair Julia, I'd like to piggyback a little bit on that. The fact that you're here on a Zoom meeting presenting this very, very detailed report to us just speaks volumes about your passion and your intensity on your subject matter. And again, you guys are to be commended for your outstanding efforts. Super proud of you. It's really exciting to see what you're doing. Thank you.
Thank you.
I guess from our perspective, we only wish that this ordinance was in play before that building started to come up. So, which for the record, I don't think that building ever came before the Planning and Zoning Board. So I don't think we as a board had anything to do with approving what is being built there. And obviously, for the record, I don't agree with what's being built there, but I don't think I had any power to do anything about it. I want to commend again, like everybody is saying, you guys coming up, it's 8:30 at night. I'm sure that there's plenty of other things that would have you could find to do today, and you decided to share your concerns, and you went far beyond just what you saw there at the beginning, because you just didn't even talk about moving the property from the side, but you took on the issues of the beverages, the gas. I hadn't even thought about having gas stations next to schools and what could happen, potentially speaking. And so, I mean, that really, you went above and beyond, in my opinion. Just a simple look. And you guys have, great presentation, especially in this new era. I'm sure that we were all welcome to be able to be there in person and and shake you guys' hands and congratulate you. But I guess, I don't know, social distancing doesn't allow that anymore. So all the best to you guys. I'm sure with what you've done already, your future is only going to be brighter. And I'm glad that you guys are part of our town. And we definitely are, whatever support we could bring on. And technically speaking, we would, as a board now, entertain motions to recommend approval of this. And that's going to be technically the next step. But I just, again, wanted to congratulate you guys on a great performance and thank you for taking time to think about what we could do every day to better our community. So I get this moment, I'd like to open up to motion.
And maybe before you do that, I have to say the staff report and everything that has been presented in front of you has been finally written and approved by staff. So this is a staff application at the end of the day, because they are not, public is not allowed to present ordinances to the council. It has to come from staff. However, I have to say that they did not only participate, but do the first draft of everything you have in front of you. So, and it was very good to begin with. I had to fix some things, but it was very, 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 very good and very complete to begin with. They even attempted to answer all the particular questions as to the comp plan. It was a fantastic staff report. I have seen well-seasoned planners do worse. I was very, very impressed with their work and their capacity for it. I'd take any one of them as an intern.
Nice.
That's, yeah.
Great. No, and we also, I guess, as a board, want to thank staff for working with our students, because I think it is important to bring on board the interaction of our students and all our members to work together. I mean, at the end of the day, we are one community, one group, looking out for the best interest of all of the people in Miami Lakes and our surrounding communities. So kudos actually to the town staff as well for helping with the students. So,
It was, Chair, it was a pleasure. We went to Miami Lakes Middle. We sat with them. They have a moot courtroom a mock courtroom in their school. They take a lot of pride in trying to learn how to draft laws and learning about the Constitution, learning about the different delegation of different responsibilities of different governments. And it's really, really amazing and inspiring to see them all put such passion behind
That's
this.
amazing.
great.
That's amazing.
Through the chair.
Yes, please.
Through the chair. Yeah, I first of all, I wanted to congratulate all of the students. You guys did a great job. I actually went to Miami Lakes Middle School when it was called Miami Lakes Junior High. So many years ago. And it was before it was called Miami Lakes Middle. But I was never in the position that you guys are in. I wasn't engaged as you guys are clearly engaged. And I want to, again, commend you guys for doing it. This is what it's about, being civically engaged. And I think that everyone on the board feels a responsibility to give back in some way to the community. And clearly that's what you guys are doing. So I want to congratulate all of you guys for that.
Thank you.
Okay, thank you. So at this moment, I'd like to entertain a motion. If one of our board members would present a motion, Board Member Young.
I will put the motion to approve it as is.
Okay, we have a motion. Is there a second?
I'll second the motion.
Okay, we have a motion by Board Member Yanes, second by Board Member De La Sierra. I think this one we could do probably a voice vote. I mean, all those in favor?
Yes.
Aye. Yes.
Aye.
Aye.
Anyone opposed? No. So
Motion
seeing that
passes.
there's no opposed, I say that this motion has been approved to recommend approval by the Board of Commissioners. So thank you. You guys did a great job. So this is the first hurdle. I guess now you will have an opportunity to present in front of our mayor and councilman. I'm sure you probably want to do a Zoom meeting there too. I don't know if maybe by that time we'll open it up. Do we know when this would go back to the board?
They will be heard by the council. Well, the ordinance will be heard by the council on the next May 21st meeting. Is it May 21st or May 20th meeting? So that would be the first reading, and then they'll have the second reading in June sometime.
Okay.
Maybe by June we would be in chambers again.
Okay.
Maybe.
Hopefully.
Yeah, so they can get the whole finance. Yeah.
Great. So basically, obviously, we've just recommended approval. Now it would go to the first reading, and then in the second reading, it'll actually become part of our town code, thanks to your effort. So on behalf of the board, we'd like to again thank you for your input and work into this. And again, we only regret that it's happening now and not sooner, and other things could have stopped, but we'll see. Thank you again.
Thank you. If I'm allowed, can I ask a quick question?
Sure.
Is there any way we can get the recording of this meeting?
Yes, this is part of the public record, and I'm sure there's mechanisms to do that.
Yes, this meeting is recorded, and actually when this meeting ends, this recording will be available on our town website.
Okay, perfect. Thank you so much.
Thank you. I guess the next item would be the director's report, if there is one.
Well, I just always like to bring you news of what you previously worked on. We have finally passed the ordinance and the resolution regarding the mobility fees. That was done in the last hearing. Also, the driveways in the West Lakes was approved finally on second reading as well. And the landscape and artificial turf ordinance will be heard hopefully in the next town council meeting. Apparently we have to rearrange some of the things that are on that ordinance, and it's going to be heard maybe, am I correct, Mr. Coviella? Are we shooting for May first reading for the artificial turf?
Probably not. It's probably going to go in June.
So your work at changing the code of the town of Miami Lakes is continuing nicely, and we're slowly but surely getting around to a lot of stuff.
Thank you. Okay, so at this time, no further items on the agenda. I call them adjourn the meeting. So thank you guys again for this Zoom meeting. Thank you, the town, for backing us up, especially this one that had so many people.
Yes.
I think it was pretty flawless. So
Great job, everyone.
You did great.
Great job. Thank you, Mr.
Yeah,
Chairman.
you did great, Mr. Chairman. Everybody stay safe.
Awesome.
Be safe, guys. Take care of yourselves.
Yeah.
All right,
Good to see
take
you.
care.
Yourself
Stay
and your
safe.
Good to
families.
see you all.
thank you, Michael.
Bye, guys.
Nice to see you all. Thank you.
Bye.
Thanks for your assistance.
Thank you.
Thank
Have
you.
a great night, everybody.
You too.
Ciao.